Thank you very much, Mr. Anurag Goel, Mr. Ashwani, all learned and distinguished participants, distinguished guests, Mr. Harry Dole, Madam Dole, Madam Iqbal, Madam Kamia, ladies and gentlemen, friends from media, officers of local administration, my good afternoon to all of you. In fact, the topic that was given to me was transparency in judiciary. That, of course, is latest, hot, and current one. It has assumed so much of importance that even government has started feeling and thinking that a seesaw change is required in the judiciary as well as in the judicial system. Now the question is as to how this topic has cropped up all of a sudden. The reason was that one of the former judge of the Supreme Court who woke up all of a sudden of 7 years of slumber and said something with regard to the working of the higher judiciary, that is High Court and Supreme Court and so on and so forth. He took up the issue with regard to confirmation of one of the judges of the Madras High Court. Unfortunately, he is no more with us. And he said that even though that learned judge had a bad track record, but as many as 3 former Chief Justice of India went on to either extend his term or to confirm it, ultimately. What the learned judge has disclosed to the media and what we have come across through the papers may be correct to some extent. But the question is, why did he keep quiet for 7 long years? According to my own assessment, it was ill-timed. Many stories are going around as to why he chose this particular time, but I am neither concerned nor interested to know it, but public is clever enough to calculate and to say 2 plus 2 is 4. In fact, this caused a serious debate amongst the common man, the law minister and other senior ministers, who had to call a meeting of all those stakeholders. Some of the former Chief Justice of India also attended that meeting and then expressed their views as to what should be the mode, how a court should be adopted, so that let there be a complete and absolute transparency in the working of the High Courts as well as the Supreme Court. In fact, India is the only country where appointment of a High Court judge and appointment of a judge of Supreme Court is made by the judges themselves. For High Court, the system is, for High Court, how a judge is appointed. For appointment as a judge of the High Court, a potential candidate is recommended by the Chief Justice of that state plus 2 senior most judges. For Supreme Court, the system is that the Chief Justice of India plus the 4 senior most judges, they call a potential candidate, take his consent and go ahead with that. But as far as appointment of the High Court judge is concerned, his case also comes to the Supreme Court, and then again a Supreme Court judge, Chief Justice of India, and 2 more senior most judges, they constitute the committee that is popularly known as collegium. They recommend. So for High Court judge, it is 2 stages appointment committee. For appointment in the Supreme Court, senior most judges or the Chief Justice of the respective High Courts, they are picked up. And then their matters are considered by the Chief Justice of India and 4 most senior judges of the Supreme Court. At times, eminent jurists from the bar are also called so that their cases also could be considered. But such cases are very few. So you will understand from this system that it is only the judge's prerogative as to who should be appointed and who should not be appointed. Generally, reasons for selection or rejection are recorded in very short, and candidate at least does not come to know as to what are the reasons recorded either for his selection or for his rejection, as everything is kept in a sealed cover. It is then sent to the government for its approval. Government may recommend or government can say, no, we don't agree. But that refusal can be exercised by the government only once. If it comes back to the High Court or the Supreme Court collegium once again, then, and if the name is reiterated, then the government will have no choice. But they will have to agree to whatever has been said, either by the High Court or by the Supreme Court. So in a way, you will come to know that, that the executive has got no power. It is the sole and whole responsibility of the High Court or the Supreme Court to appoint their own peer judges. The meetings of the collegiums also raise several doubts of its uprightness. At times, it becomes a formula of compromise or give and take. I am saying so as I have been the judge of at least 3 high courts, that is Madhya Pradesh, the state to which I belong to, then state of Karnataka, and then state of Rajasthan. And only thereafter, I was picked up in the Supreme Court. In 1 or 2 cases, when I was a judge of the High Court, I wrote a dissenting note with regard to a particular candidate. But since other 2 judges, they were in his favor, they ruled in his favor, and I was in minority. So ultimately, that particular gentleman became a judge of the High Court. Now you can well imagine my predicament when he takes over as judge of the High Court. He takes oath as a judge of the High Court, and he sits next to me in the bench. And he knows, because by that time, since he has already taken oath as a judge of the High Court, office is also, registry is also kind enough to inform him that, look here, in your case, so-and-so judge had written a dissenting note. Now he is sitting next to me, I am also feeling uncomfortable, and so is he. But he has no choice. He can't ventilate his grievances. But at times what happens, the atmosphere in the bench, that is little spoiled. So, but there is no way out to avoid these things. They ought to happen. Howsoever institution may be working so well. Now let us come to the history as to how this system of collegium came into existence. What was the reason? The Constitution does not provide anywhere with regard to system of collegium. It is a creation on account of 2 judgments of the Supreme Court of India, which were presided over by as many as 9 judges. And they thought that this system of collegium may do little better than the earlier system. It was evolved almost 20 years back.
What was the earlier system?
Earlier system means government also used to participate. They also had some say. So this system has been working for last about 20 years. Now in my own humble assessment, that every system has got its own life. And according to me, now this system of collegium has outlived its life. It needs a change. Now what should be the change? That is the bigger question. Because once I happened to meet Honorable Mr. Justice J.S. Verma, former Chief Justice of India, who was he was the architect of this collegium system. He also told me that, look here, now this system is failing. The government and the judiciary must think of some other better system. Now there is a move to have a judges appointment commission or any other body created for appointment of High Court and Supreme Court judges. But as I said, whether that is going to do better than the existing one, that is a larger question to be considered. But I still feel that there is no harm in giving it a trial. If committee is broad-based, it consists of the present Chief Justice of India and some of the former eminent Chief Justice of India, plus some eminent jurists, including the Law Minister and some member of opposition, and committee is broad-based, they considered a candidate's potential from all angles. There is no reason that why it should not do little better than what is going on now. But the question is whether we can afford to take this big risk. I say risk because so far in the Indian judicial history, not a single judge has been removed, because the removal itself is very cumbersome. Unless a judge is impeached, he cannot be removed. On earlier occasions, there have been at least 3 instances where 2 High Court judges and 1 judge of the Supreme Court of India were tried to be impeached. But before the motion could be brought, the 2 learned High Court judges, they thought it fit to resign. So the motion of impeachment, it was dropped. In the case of the judge of the Supreme Court, the Congress remained out. It did not vote. So that is how the judge was bailed out by the Congress government. So this would show that once a judge is appointed, then his removal is very, very difficult, almost impossible. So many ifs and buts. And unless all those ifs and buts are taken into consideration, it will do no good. So, before a judge is appointed, it is all the more necessary that he should be examined from all angles so as to see to it that the best is taken. But at times, that also fails. My personal experience is that when we think of taking of the best of the lawyers who may be having all qualities of making it an excellent judge, but they also fail. Because if success starts sitting on the head of a judge, then nothing will work. So, so as far as this appointment of judges is concerned, I think it is enough. Now, I will also give you some viewpoint as far as the arbitration cases are concerned. Most of you must be aware and most of you must be engaged in many arbitration cases. And I am sure you must not be satisfied with the manner in which those cases are decided or those cases are considered on day-to-day basis. To be honest with you, even I am not satisfied with the manner in which the cases of arbitration progress. Thus, the very purpose of sending the matters to the arbitration are defeated. You would recollect that Section 89 of the CPC, which provides for alternative dispute resolution, was brought into the statute book only with an intention to provide an early, quick, fast, cheaper, and and justice to the litigant who are knocking the doors of the courts, but that has not achieved its result to the fullest. In Arbitration Conciliation Act 1996, Part 3 deals with sections 61 to 81 with regard to conciliation. it provides a complete code as to how a matter has to be decided by a conciliator. The procedure is that one of the parties should agree for sending the matter to the conciliator, and others should also give his consent for this being decided by the conciliator. Then a conciliator is appointed. It can be, in a case, one conciliator, it can be two, it can be three, looking to the desire of the parties. Then the conciliator hears the matter. He takes into consideration the submission that may be advanced by the claimant, by the respondent, from both sides, and then he can draw his own conclusion. The best part for the conciliator is that neither the Code of Civil Procedure nor the law of evidence is applicable to him. He has got his own way, he has got his own method to adopt and to decide. According to me, instead of the parties going to arbitration first, they should first try to get the matter conciliated, to get the matter referred to the conciliator so that he may be able to decide the case one way or the other. And in any case, parties are not going to lose anything, for the simple reason, if the conciliation fails, then parties would still be at liberty to go to the arbitration, because conciliation would automatically stand terminated once he reports that, no, I am not able to come to any solution between the parties. This would be, of course, cheaper and faster both. Now here I would like to give you my personal experience with regard to how a matter can be settled and out of the court or maybe within the court. When I was a judge of the Supreme Court of India, on every Mondays and Fridays, 10 to 15 cases used to come to our court for transfer of matrimonial disputes from two different places to one place, because husband would file at place A and obviously wife would file at place B where she would be residing. Now, then if two matters are going on at two different places, the only mode is section 25 of the CPC, where Supreme Court can interfere if one from matters to be transferred from one state to another state. Obviously, then whenever we used to have such type of matter, we used to call the parties so that we could work out whether any amicable settlement can be arrived at between them. When we used to call the party, we thought that they are fighting for very trifle issues, that is virtually non-existent, only ego problems. Sometimes we try to settle ourselves, but in case we were not able to do so, we used to send it to the to the mediation center created by the Supreme Court of India, having expert mediators. And believe you me, supposing we have sent 10 cases, out of 10, at least 5 to 6 cases used to be settled between them. This is the success ratio of the conciliation and mediation center. Applying the same logic, according to me, if parties also try to settle their disputes through conciliation, through mediation, there is no reason why it should not be sorted out. Now, coming back to the arbitration, I would like to tell you that as long as there is single arbitrator, sole arbitrator, things are better. But if the number of arbitrators are increased to 3, then things become really impossible, because 3 of them, generally what happens, they are either the former Chief Justice of India and 2 retired judges of the Supreme Court. They have no time, they are not able to give dates. So it is always better to have a single sole arbitrator rather than having 3 arbitrators. This is my personal experience. Now, Mr. Harry has already told us as to how a judgment can have adverse effect to the economy of the country. You are well aware of that judgment. I need not take the name of that particular judgment, but I would only give you my personal experience after that judgment. At least 3 big companies of 3 different countries came to me for my opinion, because according to them, they told me that one of the company had invested 16,000 crores, another company had invested 9,000 crores, and only with the same brush everyone was painted and their licenses were cancelled. When they were to come to India, they were shown that, look here, this is a golden goose, you invest, you will get this, you will get that. But now the question was, even they were not able to get the money that they had invested. Forget about the profits, etc. What had happened because of that? The result was that FDI fell. FDI fell to a great extent because the countries which were ready and willing to invest in India, they got a shock of their life. They decided, no, enough is enough, we are not going to invest. So my humble request to the honorable judges is that they must realize the ground realities. They must see as to how the judgment is going to affect the country, how the judgment is going to affect the economy of the country. Unless that is seen, it is not going to serve any purpose. I think I have said enough, and I would like to call it Omega. My thanks to Mr. Harry, my thanks to all the organizers, my thanks to all of you for giving me a very patient hearing. Jai Hind.